termination agreement is an agreement between an employer and employee. It governs the rights, responsibilities, and benefits of the parties arising from the termination of the employee. Employee termination is the process by which an organization ends an individual's employment. A termination agreement, also referred to as a separation agreement, refers to an agreement between an employer and an employee in which the employee agrees to terminate employment voluntarily. The employee waives his or her right to challenge the termination or to sue the employer under all state and federal laws and union or civil service protections in return for some type of compensation or consideration by the employer, usually a severance payment or some other type of monetary benefit. In general, an agency may want to consider a termination agreement in one of the following situations. When the employee has specific rights to a hearing, such as the right to a veteran's preference hearing, grievance arbitration, or civil service hearing, especially if the employee has the right to more than one of these hearings. When it is in the best interest of the employer to avoid a lengthy legal battle or any other resulting negative publicity. When it's in the employer's best interest to ensure the employee is removed from the workplace quickly and permanently. And finally, for other legal reasons, as assessed by an attorney familiar with public sector employment law. Laws require certain waiting periods or other procedural requirements before such an agreement will be considered legally binding. For example, the Age Discrimination in Employment Act, or ADEA, requires that an employee be given 21 days to consider whether to sign the waiver. It also requires a 7-day waiting period after the employee signs the agreement in which the employee can change his or her mind or cancel the agreement. The contents of a termination agreement should include several elements. Let's explore. The employer will want to have the employee sign a release of claims under the Minnesota Veterans Preference Act, the Minnesota Human Rights Act, Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, and the Americans with Disabilities Act, as well as any other local, state, or federal laws relating to illegal discrimination in the workplace on the basis of religion, race, disability, sex, age, or other characteristics or traits. The employer will probably also want the agreement to contain a release from any claims that the employee may have been wrongfully discharged, any claims that an employment contract has been breached, any claims that the employee has been harassed or otherwise treated unfairly during employment with the agency, any claims that the employee has been defamed in any fashion, and any claims for punitive or compensatory damages, back pay, front pay, fringe benefits, or attorney's fees. In most cases, the agreement should contain also, at a minimum, a statement that the employee acknowledges and confirms his or her resignation and the effective date of that resignation. A listing of the benefits and severance pay that the agency is offering to the employee in exchange for release of claims. A statement that the employee acknowledges the agency has fully and properly paid him or her for all hours worked, provided and has received all wages, salaries, and earnings in which he or she is entitled. A statement that the agreement does not constitute an admission of the employer of any wrongdoing. A statement that the employee has been advised of his or her right to consult with an attorney before signing the agreement. A statement that the employee understands he or she may cancel the agreement for any reason within a certain period. And finally, a statement of the specific reasons for the agreement, particularly where more than $10,000 in public money is involved. The agreement cannot limit access to or disclosure of personnel data or limit the discussion of information or opinions related to personnel data to the extent that this information would otherwise be accessible to the public. An agreement or portion of an agreement that violates this prohibition is void and unenforceable. Specifically, an agreement cannot be made that would prohibit or limit 1. Discussion, publicly, or comment on personnel data or information that could otherwise be made accessible to the public, or 2. The ability of the employee to release or consent to the release of data that would otherwise be made accessible to the public. Ideally, a management representative, who is likely to be seen as neutral and objective, discusses the termination agreement with an employee. In most cases, it's not ideal for the agreement to be discussed or delivered by the employee's immediate supervisor. It's also a good idea to have more than one management representative in the room to serve as a witness. Finally, a private, neutral setting, such as a city attorney's office, is generally best for discussions with the employee on a termination agreement. Severance pay refers to a payment made to an employee upon termination of employment, usually for reasons beyond his or her control. It is also sometimes offered in conjunction with a termination agreement, as we've discussed. In these cases, the employee releases the employer from any claims or waives their right to sue the agency. Minnesota law does, however, allow organizations in the public sector to offer severance pay in addition to payment for accrued leave. The law, however, limits how much an agency can pay out in severance. In order for the employee's release of claims and waiver of rights to be legally binding, the employee must receive something in consideration. Usually this takes the form of severance pay. It's not enough for the agency to offer the employee a payment that he or she would have otherwise been entitled to upon termination, such as payment for all of an accrued leave. The payment must be above and beyond what he or she is otherwise entitled to. There is no common practice among Minnesota agencies on the type of severance payment that would be offered in conjunction for waiving rights or release of claims. It varies generally between agencies depending on individual circumstances involved with terminations. A highly compensated employee may not be paid more than 6 months of wages under Minnesota statutes, except under certain circumstances. A highly compensated employee is defined as an employee with estimated annual wages that 1. Are greater than 60% of the governor's annual salary, or 2. Are equal to or greater than 80% of the estimated annual wages of the second highest paid employee for the local unit of government. An agency may exceed the 6-month limitation on wages paid as severance pay to highly compensated employees if one of the following criteria is met. The severance pay is part of an employment contract with the employee that was in effect on August 1st, 1993, and the termination occurs before the expiration of the contract. The severance pay is part of an early retirement incentive program available to all other employees who meet specified criteria, or the Commissioner of the Management and Budget Office determines that the position requires special expertise that necessitates a larger severance pay guarantee in order to attract or retain a qualified person. Even if an agency meets the criteria for exceptions of the 6-month limitation on highly compensated employees, it still may not exceed 1 year of wages. Federal and state law governs rescinding a separation agreement. The Age Discrimination in Employment Act requires that whenever an employee is waiving his or her rights under the law, he or she must be given 7 days in which to revoke his or her decision. The Minnesota Human Rights Act requires a rescission period of 15 days. The rescission periods cannot be shortened, neither by the employer nor the employee electing to shorten those time periods. The agreement does not become effective until after the applicable rescission period has passed. Many employers, therefore, delay payment on severance or other consideration to the employee until after the rescission period has expired.